Dear friends, many years ago, I taught law at different universities. My major objective was always to avoid important-sounding legal mumbo-jumbo and teach my classes in easily understandable language so that every first-year student would understand what I taught. Now the time seems to have come to slip back into my old role. This is because many people want to know if there's any substance to the accusation leveled against me, or if the criminal proceeding is merely a show trial without any substance, whose true purpose is to stop me, our team, and our group of international attorneys from continuing with our legal inquiries. I will try to answer this question as clearly and easily understandable as possible. If you want to fully understand my statement, please refer to the transcript of this statement. First of all, it is important to note that I am not accused of having committed a crime, such as murder, rape, or assault. Crimes are punishable with at least 1 year imprisonment. Rather, I'm accused of having committed a misdemeanor, which is a lower-level violation of a statute. This misdemeanor is described in Section 266 of the German Criminal Code. And this Section 266 is unconstitutional on its face, as it is vague and overbroad, which means that it is not clear what kind of behavior is punishable. The precise words are as follows. A person who violates a fiduciary duty to take care of another person's monetary interests and thereby causes damage to the other person's monetary interests can be punished. Legal scholars argue that this is, if nobody knows what this means, that this is a statute whose vagueness and overbreadth couldn't be any worse, that this is a ruin of the law or an all-purpose weapon. This is a Damocles sword hovering over every decision a director of a corporation makes, because anything and everything under this section can be criminal. That is, in fact, why the German Constitutional Court says that the use of this statute should be very restrained. In fact, mounting evidence shows that this misdemeanor, as it has evolved into the preeminent business crime in German law, is now being misused as a battlefield for strategic and personal quarrels. This is what the legal scholars say, that should be left to the civil courts to solve. Indeed, the available data suggests, they continue, that those who file criminal charges against directors of corporations, and that's what I was one of the directors of and still am, one of the directors of the Corona Investigative Committee, they do this with the intent to misuse or abuse it to pressure a director into paying damages, which in a civil proceeding, they wouldn't have a chance of winning. For a better understanding of the obvious and frivolous misuse of the criminal charges in my case for exactly this purpose, I'll give you a more detailed analysis in a separate statement. But for purposes of this shorter statement, let me just summarize the facts and the applicable legal analysis. The decision that I and my former co-host made when we were informed in late October, early November of 2020 that Professor Zushari-Pakti's group's bank accounts had been attached by the authorities was to immediately remove some of the donations from our bank account so that our bank account wouldn't be attached either, or rather, in case it would be attached, we wouldn't be put out of business, but would be able to continue paying our manager, our IT, translators, etc., and would be able to continue with our work. We decided to do this openly and transparently by way of a loan contract, which was, of course, duly listed in the books of the Corona Investigative Committee. And as even the court agrees, I was always both willing and capable of repaying the loan. I mean, I had lots of real estate worth over $2 million, way over $2 million. Why would I not do this? I was the face of the Corona Investigative Committee. I was the one who was trying to make this known on an international basis. I gave interviews 5 days a week everywhere, all over the world. And I was the one who coordinated an international legal response, or was working on such a coordination. So why would I steal my own money? It doesn't make any sense. Our bank accounts were in fact really in danger. There was a real and imminent danger because since late July of 2020, right from the beginning of our work, our bank accounts, the Corona Investigative Committee's bank accounts, were being canceled by the banks, and the banks informed the authorities of possible money laundering. We knew that. We just didn't know how far that had gotten. In the meantime, from the files of the district attorney, we know that they came really, really close, and the German version of the FBI was after us. The question now is, if this business decision was a violation of a fiduciary duty owed to another person to take care of their monetary interests. Well, we believe that it is not a violation of this duty because, and we don't even know what this duty might be. If there is a duty owed to anyone, then it is to the donors, of course, not to the people who are accusing us of criminal activities. Because under civil corporate law, this decision would clearly be covered by the famous business judgment rule. This is clearly a reasonable decision under the circumstances. We were under the impression that an attachment of our bank account was imminent, so why not save some of the money, especially since we were perfectly able to repay the money from the assets that we had. And most donors and viewers of our show and our interviews had donated their money, of course, so that we would be able to conduct these interviews and show those real corona facts that the mainstream media and politicians didn't want us to know. And of course, these donors and viewers would not have wanted their money to be taken by the very state actors, including, of course, the German judiciary, whose actions we were questioning. At any rate, here in this overview, let me now focus on the highly dubious statute and the even more dubious actors we're dealing with in my case. So where does this statute come from? What are its origins? Easy. This statute was introduced into German law and included in the German criminal code during the reign of the Third Reich by Hitler's Nazis in 1933. This was made possible because the infamous Empowerment Act had enabled Hitler's goons to bypass the legislators and get laws passed by the executive branch, which is by the Nazis themselves. In fact, one of the most murderous of the so-called terrible judges of the Third Reich, the president of the then equivalent of the Supreme Court, Roland Freisler, who sentenced the members of the resistance group around Count Stauffenberg, who tried to assassinate Hitler on July 20, 1944 to death, weighed in on the importance of this statute and demanded in a law review article that this statute should be seen as a traitor's statute. These words from Germany's very dark past take on an astonishingly appropriate meaning in the context of my case if we look at the actors involved, only much different from what the murder of Freisler had in mind. Let us take a closer look at the actors in my case and at their actions. Let me focus on the 3 Berlin attorneys who filed the criminal charges against me on September 2nd, 2022. There are 6 reasons for us to conclude that all of them acted to destroy both the Corona Committee's work and its successors, ICIC's work, by defunding us. Reason number one, out of the 3 attorneys who filed the criminal complaint, only 2 were ever members of the Corona Investigative Committee, and these 2 were only brought on board by us as substitutes for 2 renowned scientists who had backed out of our work just before we started with our work. 2, these 2 replacements had never played a role in the Corona Investigative Committee's work, were in fact never interested in its work, and had left already in late 2020 to start their own show, which, however, failed because nobody wanted to watch it. 3, on numerous occasions, these 2 had demonstrated to my former co-host and me that they were only interested in the donations. I'll go into the details in my next statement. This will be shocking. 4, now with the help of the district attorney and the criminal court, they are actually asking the court to award these donations to them. If they succeed, they will end up winning roughly 5 million euros of the Corona Investigative Committee's money, my client's money, and even Viviane Fischer's money. 5, this is all the more astonishing in its brazenness, as the Corona Investigative Committee's bylaws explicitly state that none of the directors and shareholders shall receive any payment for our work. They didn't work in the Corona Investigative Committee anyway, and we shall not get any severance pay, no money, if we leave the Corona Investigative Committee, if we leave our position as shareholders in that corporation, because the money, the donations are only there for the work of the Corona Investigative Committee. And 6, it is now obvious, especially from a commentary written by my former co-host and filed with the district attorney, a commentary on the criminal complaint, that pretty much all of it is falsehoods and outright lies, punishable. All of this seems rather unbelievable, but it gets worse when you go into the details of this, which I will do in my follow-up statement. And it appears that the district attorney and the court are slowly but surely realizing that something is terribly wrong. This is only after they started with the actual trial. This is when I finally was able to tell them my side of the story. And now through the hearing of the witnesses, they're beginning to carefully understand that some of these people are simply lying to them. Now, just to make this perfectly clear, there cannot be a shadow of a doubt that those who filed these criminal charges or the criminal complaint against me are using or misusing criminal law for the purpose of extorting money from me and us, which they wouldn't stand a chance of winning if they sued me in a civil court. Their civil complaint would be immediately thrown out because the applicable corporate law, that is, the bylaws of the Corona Investigative Committee, explicitly prohibit such payments. At any rate, we have 2 conflicting stories. One is that of my accusers. They're saying Reiner secretly stole money from the Corona Investigative Committee to have to live the high life. Our side of the story is we did take that money, but we didn't do it secretly or covertly. We did it openly through loan contracts, which were duly listed in the Corona Investigative Committee's books. And we did it to secure some of our donations from an imminent and acute danger of attachment by the DA's office. And of course, I would have repaid the loan just as we had planned to do, and even discussed this in public when my former co-host and others decided to make it public, which they hadn't. But I would have repaid the loan, of course, from the proceeds of the long-planned sale of my house, had the accusers not stolen that money by way of fraud and extortion. Now, I want to finish for now. Hang on. By thanking you once again for all of the postcards and letters that you wrote me. This is what keeps me going, incredibly enough. I read everything, and I can't tell you how much this connection with all of you means to me. Finally, music, which I listen to a lot, also connects people, I believe. Therefore, I will start sharing with you some of my favorite songs so that you will, if you're interested, be able to learn a little more about me. I'll start with the first 5 songs, and those are Tina Turner, Private Dancer, Pink Floyd, Another Brick in the Wall, Rupert Holmes, Escape, also known as the Pina Colada song, Rod Stewart, the Motown song, and Robert Palmer, Johnny and Mary. Thank you very much. We will not give in. We will win. See you later.